Good afternoon, listeners. Welcome to the next stage of today's presentation. We just concluded with the introduction to our topic for today, which deals more on cultural impact assessment, or simply put, cultural heritage impact assessment. Our next discussion, as we have in our presentation slide, we'll be talking about laws and policies in cultural impact assessment. My name is Matthias Ayeye. The Environmental Impact Statement Guidelines has adopted both social and cultural variables, among others, to guide its investigation in addressing the social components of the EIA. As the social component of the EIA is known as the social impact assessment. Now, while some environmental impact statement distinguishes social variable from cultural variables, some sums the cultural variable under the broader social variable and treat culture as part of the social dimension of environmental impact assessment, that's the EIA, on the assumption that the social impact assessment will adequately cover for all cultural issues and concerns. Now, our first presentation dealt more and discussed and gave us a definition of what the cultural impact assessment is, where we're made to understand that it's a process of identifying, predicting, evaluating, and communicating the probable effects of a current or a proposed developmental project on the cultural life, institution, and resources of communities, and thereby integrating the findings and conclusion into the planning and decision-making process of such projects with a view of mitigating adverse impact and enhancing positive outcomes. Now, it could be deduced from the definition of cultural impact assessment that cultural impact assessment is predicated on the notion that decision makers should understand the consequences of their decisions before they act, and that the affected people will not only be appraised of the effect, but also have the opportunity to participate in the decision-making process of the project and in designing their future. Now, looking at this definition, we'll now get to understand the fact that, as we said, understanding the consequence of their decision before they act, the affected people being appraised, and the opportunity to participate in designing their future. Now, the goal of this impact assessment, therefore, it's to enhance the preservation and promotion of the cultural diversity of affected communities, because every individual had come from a community, and that community has a culture, and this culture must be preserved, and that is with a view to ensuring the sustainability of the development actions and policies. Now, in this way, it provides for planners and decision makers with better information about the consequences which their developmental action and policies could have on the cultural environment. This cannot be it cannot be achieved on its own. That is, it had to be done through some policies. And this will lead us to the key topic of today, which had to do with the laws and policies in cultural impact assessment. A cultural impact assessment doesn't take place in a vacuum. Apart from the fact that it is undertaken as a response to a particular situation, a proposed developmental action or a policy change, it also has to be mandated by statutes or regulations already in place to provide authorization for the exercise. Now, an examination of this cultural impact assessment exercise in most countries shows that the National Environmental Act is the primary legal requirement for a cultural impact assessment. Because without the National Environmental Act, there won't be the EIA under which the CIA falls in. Now, the cultural impact assessment is therefore, in a nutshell, an investigation of the effects of development policies or actions on the cultural aspects of the human environment. Because the world as we have it today is discussing more on sustainability, sustaining the environment. And when we talk about the environment, the human being, the humans are a key component in the entire environment. And the humans have a way of interacting with the environment, and these have to be their culture. So this culture has to be sustained. Now, these laws, these policies, this convention we're looking at cuts across a lot of phases. Because these laws, we have both the international law, we have policies, international conventions, and each country has theirs. As we earlier said, that there must be a national environmental act that would govern each assessment to be done. Now, we'll be looking at majorly two of these international regulations. We'll be looking at international regulations, and we will be coming down to look at two of the key content or key areas where we have these regulations governing cultural impact assessment in Nigeria. Starting from the international regulation, we have the World Heritage Convention of 1972, which sets out the duty of states in identifying potential sites and their role in protecting and preserving them. Now, all signatories to this convention have pledged to conserve not only the world heritage situated in their territory that might be known as World Heritage Sites, but also to protect its national heritage. In Nigeria, we have a couple of them. We have reserves. We have areas that have been earmarked as conservation areas that have been strictly restricted from encroachments or for exploitation or exploration. These areas are what is being looked at, and these areas are what the World Heritage Convention of 1972 talks about. Now, this same convention encourages all to integrate the protection of the program. That's setting up, you have staff, you have service, like an agency to protect such sites. You take up scientific and technical conservation research and adopt measures which give the heritage a function in the day-to-day life of this community. Now we go to the second regulation, which we'll be looking at, which had to do with the World Bank Environmental and Social Standards, number 8, that is strictly talks about concern with cultural heritage. And this cultural heritage reaffirms the objectives of the operational policy and bank procedures 4.11 of the World Bank. Now, this standard requires projects to use especially chance-find procedures and other approaches to protect cultural heritage and provide for consultation with affected communities. Now, this standard 8, broadens a lot of definition, and it broadens the definition of cultural impact assessment, and it also defines the treatments that must be given to cultural heritage to include both tangible and intangible cultural heritage, as earlier discussed in the first presentation. Now, it also identifies different types of cultural heritage, and it clearly sets out specific requirements when the project will use cultural heritage for commercial purposes. Going further, we will be looking at the International Finance Corporation IFC Performance Standard number 8, which also talks about the cultural heritage. Now, this specifically recognizes the importance of cultural heritage for sustainability, that is for both current and future generation and users. Now, this particular standard gives guidelines how to protect cultural heritage by ensuring that internationally recognized practices for the protection, field-based study, and documentation of cultural heritages are implemented. Now, it also develops provisions for managing chance finds, requiring any chance find to be undisturbed until an assessment by competent professionals is complete and management actions are identified. Like earlier discussed in the first presentation, the various stages where it was clearly spotted that qualified professionals, competent professionals must be engaged in carrying out cultural heritage impact assessment. Now, this particular standard also provides for consultation with affected communities to identify cultural heritage of importance and to incorporate their views into the decision-making process, which is more is contained more in the overview of the definition of the impacts, this cultural impact assessment. Now, it also allows for continued access to cultural heritage sites for communities that have used the sites within living memories for long-standing cultural purposes. It also provides that there should be avoidance or impact should be minimized to these sites. And it also states that non-replicable cultural heritages must not be tampered with unless some criteria are met. Now, this particular standard spells out that there are really no technically or financially feasible alternatives in replacing some of this non-replicable cultural heritage. It states that the overall benefits of a project, though, outweighs the anticipated cultural heritage from removal, but it ensures that best available techniques must be employed in carrying out or designing the mitigation that must be carried out during the assessment. Now, these are some of the renowned international agencies that has come up with regulations guiding and protecting cultural heritage. Now, if we have to streamline some of this, we also have a lot of declarations. We have a lot of declarations, a lot of conferences, like earlier stated in the first presentation, the 2001 UNESCO Universal Declaration on Cultural Diversity, and the 2002 Istanbul Declaration. Now, streamlining to a particular form of development, which is mining. Now, the International Council on Mining and Metals also has come up with some principles to also manage the environment, though we know what mining it's all about, what mining entails. Though the world today is embracing sustainable mining, making sure that these resources are managed for present use and for future purposes, future uses. Now, the cultural heritage of man is among these policies that the International Council on Mining and Metals has also promulgated. Now, the ICMM develops 10 principles. Now, the one concerning cultural heritage clearly spells out, saying we must uphold all fundamental human rights and respect cultures, customs, and values in dealing with employees and others who are affected by activities. Now, because of the impact of mining, this has been spelled out, and these are part of what must be met, because they will make up entire reports, which might end up becoming a component of the entire ESIA that is developed before projects approval for operations are given. It also said that organizations, agencies, and individuals who are going into mining must contribute to the social, economic, and institutional development of any community they plan to operate. Now, this gives clear provisions to ensuring that cultural heritage are duly and well protected. Now, a lot of countries, like I said earlier, have policies, have conventions, have laws guiding the operations or protection, rather, of cultural heritages. Like in the United States of America, for example, there's a National Environmental Policy Act of 1969, which calls for the integrated use of social sciences in assessing impacts on the human environment. And we know when you are assessing the entire environment, like I said earlier, the human factor is not left out. Now, bringing in the social science parts of these assessments into the human environment, you clearly be talking about the culture of humans themselves. So that is where this comes in. Going a little further to a country like South Africa, neighboring African country, where there is a provision in their section 38, subsection 1 of the National Environmental Management Act that requires that any party who intends to undertake a developmental activity must notify responsible heritage resource authority and to furnish it with all necessary details. Now, this clearly spells out cultural heritage impact assessment, because these had to be done for you to be able to furnish the authorities with clear details. Now, it states further that if the heritage resource authority believes that heritage resources will be affected by such development, it will require the developer to submit a heritage assessment report. I mean, this is what is contained in the South Africa National Environmental Management Act, Section 38 of Section 1. Now, it clearly has shown now that all countries over the world have developed a form of policy to ensure that the culture of man, of humans, is duly protected. Now, coming to our country, Nigeria, we have our national laws. We have the Constitution of the Federal Republic of Nigeria that has presently been reviewed by the legislative arm of the government. But within this, there are other acts that have been provided to manage and ensure the sustainability of the culture of man. Now, first, we'll be looking at the EIA Act E12, Laws of the Federal Republic of Nigeria 2004. Now, this act provides that all projects, depending on the scale, as approved by the Ministry of Environment, that are the chief custodian and implementer of this act, shall undergo an environmental impact assessment as a requirement prior to commencement of all operation. Now, the impact as the projects we are looking at here are not just maybe a one-sided project. It had to do with every form of project that will be executed, and it's going to be that would affect the environment. It had to do with developmental projects, with the extractive industry, all forms of projects, be it road construction, housing construction, or a mine is being built, or a power plant is being built, or reservoirs or dams. No matter the project, it has to undergo a complete EIA, Environmental Impact Assessment. And as it's been said these days, mostly some refer to it as environmental and social impact assessment, because the social angle of the assessment is going to be critically analyzed. So the environmental components will be looked at, the social component will be looked at, and within the social components, the cultural parts that makes up the entire social component will be critically looked at, not minding the project. Now, we will be taking one of the acts, the numerous acts that we have that's also made provision for the protection or conservation of the culture of man. Looking at the Nigerian Mineral and Mining Act, Chapter 4, Section 98, subsection 1, 2, and 3, which has been designed to protect, to ensure that the culture, the heritage of man is preserved. Subsection 1 states that no person shall, in the course of exploration or mining, carry out operations. Now, because the Nigerian Mineral and Mining Act strictly guides all mineral and mining activities in the country, it says no person shall, in the course of exploration or mining, carry out operation in or under any area held to be sacred, or permit injury or destruction of any tree or thing which is the object of veneration. Our first presentation talked about tangible and intangible cultures. Now, veneration is part of the intangible cultures. This is their belief system. Now, this subsection 2 talks about when any question arises under this section as to whether an area is held to be sacred or tree or thing, which is the object of veneration, the question shall be decided. Now, when there's a conflict on the veracity of sacred areas or objects that are being venerated, where maybe during assessment, competent individuals had assessed and coming with conflicting views, it clearly states that issues of such shall be decided by the Mining Cadastre Office on the recommendation of the Mineral Resource Committee of States. Now, the subsection 3 states a licensee or lessee who causes injury or damage to any area, tree, or thing mentioned in subsection 1 of this section shall pay fair and adequate compensation to persons or communities affected by injury or damage. Now, this section has created clearly that the cultural heritage of a community, that mining activities to be carried out must be protected, must be duly assessed, and whatever mitigation measures that must be put in place to manage negative impacts must be prompt, and wherever possible, if it can be avoided, must be done. Now, this section 119, section 119 of this same chapter 4 of the Nigerian Mineral and Mining Act states that every holder of an exploration license, either small-scale mining lease, or mining lease, or quarry lease, or water use permit, prior to the commencement of operation, application for extension of the term or conversion of a mineral must, first of all, submit to the mine's environmental compliance department 2 critical documents. 1, an environmental impact assessment statement, which must be approved by the Federal Ministry of Environment in respect of the operations to be conducted within the mineral title area. As we've earlier stated, in our first law we looked at, the EIA Act E12, which, like I said, the Ministry of Environment are the sole custodian to implement. Now, the Mineral Mining Act has clearly spelled out in section 119 that before any mining operation is done, an EIA must be conducted. Now, the EIA, the component of this EIA, like we earlier said, had to do with the cultural impact assessments, which most times is a subset of the social impact assessment that is a unit within this report. Now, it also says that an environmental protection and rehabilitation program containing all details in environmental regulations must also be submitted. Now, the EPRP, for short, as I said, Environmental Protection and Rehabilitation Program, also contains a social angle that is also looked at. The EPRP contains a social angle that is looked at, and this also is part of the requirement that must be submitted before any operation or mining operation commences. So, in essence, it clearly has stated that with provisions, with laws, conventions, policies, both local, national, and international, the cultural heritage of man is as important as the environment itself, because every man that lives in an environment has a culture, and the culture must be preserved for continuity or for sustainability. As the present generation is presently enjoying this culture, it is important that the future generation must also enjoy such, because it tells the history, the creation, and the existence of man. So it brings the past, the present, and also links the future. So these laws and policies are very, very important, because every country that implements the EIA, it's also looking out to ensure that the environment, specifically the human community and his culture, are duly protected. We will be glad if your questions comes in. Thank you very much.